Good afternoon. We're thrilled to be presenting AI in criminal justice, automated decision-making tools, and technology from policing to corrections. This panel is sponsored by the ABA section of Civil Rights and Social Justice and is part 4 in the ABA's 6-part series, AI and the Legal Profession, Navigating Opportunities and Challenges, Exploring the Power of AI, while navigating its complex legal implications. Learn more and register at, here's the commercial, ambar/org slash AI dash series, ambar.org/AI dash series. We are actively planning additional programming on a variety of issues, so please visit americanbar.org/CRSJ for updates on these programs. During today's program, we encourage you to ask questions of our panelists through the Q&A, not the chat function. If you do not see the controls, please ensure your screen is not idle. I will be monitoring the Q&A, and we will do our best to address your questions, time permitting. We will be sharing a recording of this program with everyone who has registered so that you can share it widely with your networks. We have an outstanding panel of speakers for you today, and let me introduce them to you. Clara Garvey, Training and Resource Counsel, National Association of Criminal Defense Lawyers. NACDL's Fourth Amendment Center offers training and direct assistance to defense lawyers handling cases involving new and advanced technologies in their cases. In her previous position, Claire wrote several reports focusing on the privacy and due process implications of ongoing police use of facial recognition technology. Associate Professor Sean Hill II of the Moritz College of Law, Ohio State University. Chief Anthony Holloway, Chief of Police, St. Petersburg, Florida Police Department, and Dave Shimodotra, CEO of Justice Text. I will turn the program over to Judge Dixon, who is our moderator. He is the senior judge of the Superior Court of the District of Columbia. He's the chair of the board of editors, the ABA Journal magazine. He's a technology columnist for the Judges Journal magazine. Judge Dixon, the program is yours.
Thank you, Dean Mathewson. Good afternoon to most of you, and good morning and good evening to some of you. And welcome to our program on artificial intelligence in the criminal justice system. Now, as a general matter with respect to artificial intelligence, let me start with this because I know that there are some individuals online who are approaching the subject of artificial intelligence with trepidation. So without regard to criminal justice or any other aspect, let me read this to you and see if it sounds like how you feel about artificial intelligence. And this is a quote. "Here is an enormous and incalculable force let loose suddenly upon mankind, exercising all sorts of influences, social, moral, political, precipitating upon us novel problems which demand immediate solution, banishing the old before the new is half matured to replace it, yet not many who fondly believe they control it ever stop to think of it as the most tremendous and far-reaching engine of social change which has either blessed or cursed mankind." To some of you, that sounds like a description of artificial intelligence. The quote is an old one. It's from 1868. It comes from John Quincy Adams' son, Charles Francis Adams. He was describing the impact of the Union Pacific Railroad on the country. Those are the same words that folks use today talking about artificial intelligence. Let me give you one more example. 2 decades before that, another sentiment espoused by Samuel Morse when he used Morse code to send an inaugural message from the US Capitol to a railway station in Baltimore. The message was, What hath God wrought? Once again, building us on the fears of these transformative inventions that many of us know very little about and a lot of us approach with trepidation. However, turning more specifically to our topic today, artificial intelligence in the criminal justice system, how is it used? What are the platforms? What are the risks and the benefits? Where has it worked well? And where are improvements needed? During the course of this discussion, some of the following terms are likely to arise: efficiency, accuracy, algorithmic bias, selection bias, confirmation bias, transparency, explainability, forensic analysis of DNA, fingerprint, and facial identification, predictive policing, risk assessment, data management, oversight and accountability, deep fakes, document analysis, monitoring and compliance, rehabilitation, and education. These terms and more are important not only in discussing the benefits and risks of artificial intelligence in the criminal justice system, they're also important in areas such as human resources, healthcare, medical diagnosis, data analysis, market and finance, education, and more. During the course of this discussion with these fantastic panelists, you're likely to hear some new things. You're likely to have your assumptions about certain artificial intelligence issues challenged, and you're likely to receive confirmation about some things you've already learned about artificial intelligence. Finally, and most importantly, I suspect that you will find out that not everyone is in agreement about all of these issues. First, I'll call on our panelists for general comments about some of the issues that they either hope to address during the course of this discussion or topics that they're important to be aware of. Then I'll start with questions to our panel members. We welcome your questions throughout this process. Please remember to submit your questions of our panelists through the Q&A and not through the chat function. I'll start with asking Clara Gavi for her comments with respect to items she would like us to see touched upon during the course of this discussion, or additional items that she feels are very important just for folks to know about.
Thank you so much, Judge Dixon. Happy to be here with all of you today. As was previously mentioned, I work with the National Association of Criminal Defense Lawyers and the Fourth Amendment Center at that association. While I think generative AI has gotten a lot of attention recently, and I'm sure it's going to come up a lot in the discussions today, and we certainly do see it in the criminal investigative context, and I believe we'll start to see it in the work that the Fourth Amendment Center does. Think automated report writing, 911 call triaging, that type of thing. The vast majority of AI that I will be speaking about today and that we see actively in the work that we do with criminal defense lawyers is in the criminal investigative context, what I would classify as sort of extractive AI, evidence gathering, interpretation, analysis. It's less on the generative side, and it's more on what sense can we make of mass data inputs. My particular focus, so I will be going back to it a lot, I think, is facial recognition technology. But despite the fact that it is my area of expertise, I also do think it is a really good case study and perhaps a bit of a cautionary tale for the treatment of AI and other automated and advanced tech systems in the criminal legal system for a couple of reasons. The main one being that it's been used in hundreds of thousands of cases since 2001. So we have a track record, we have cases that we can go back and analyze. What are the questions of reliability, transparency, accountability, bias? What are the hurdles to overcome? Where is the criminal legal system ill-equipped to deal with questions of advanced technology? I think a lot of these have been posed over the last 23 years and counting by facial recognition, and yes, by other tools. So that is an example that I'm going to be coming back to talk about my main areas of focus, which are the ones I just mentioned: reliability, transparency, accountability, bias in a broad sense, yes, racial bias, but also cognitive bias and the impacts that that has on the criminal legal system. Really looking forward to this discussion, and I'm very happy to be here today.
Thank you, Ms. Garvey. Professor Sean Hill, I call on you for the same purpose.
Thank you so much for the invitation, and good afternoon, good morning, or good evening to those of you who are attending virtually. So as Judge Dixon just mentioned, I've been at the Ohio State Morris College of Law for the last 4 years and teaching for 6 years. But prior to entering the academy, I practiced as a criminal attorney and movement lawyer in New York City. And in my last year of practice, before I transitioned into teaching, this was between 2017 and 2018, I had the opportunity to work on a statewide bail campaign in New York State. And that was when I first became acquainted with risk assessment tools, which will be the primary focus of my remarks and my area of expertise today. So specifically in 2016 or so, New Jersey had decided to adopt these risk assessment tools statewide. And these are tools that utilize computer algorithms to assess the probability of certain outcomes. And in the bail context, they're primarily assessing the probability that a person will be rearrested during their pretrial release and the probability that they are going to return to their court date. So New Jersey had adopted these tools statewide in order to reduce the number of people detained pretrial in its jails across the country. 75% of people, approximately 75% who are currently held in jails, have only been charged with the crime and have not been actually convicted or brought to trial. So New Jersey adopts these statewide, and as we are confronting bail reform in New York State, Governor Cuomo was also seeking to accomplish the same ends in New York. And the campaign that I was a part of was both aimed at reforming bail laws generally in New York State, but we also ended up successfully mounting a campaign against the instruments, and we secured legislative changes that, in my opinion, better protected the presumption of innocence and ensured that pretrial liberty was going to be the norm rather than the exception. So because of these experiences, along with my own research into risk assessment instruments, I am opposed to the adoption of predictive technologies, whether in the context of pretrial proceedings, policing, sentencing, or otherwise. Although many grassroots groups and nonprofit leaders share my opposition, including a particularly notable organization known as the Pretrial Justice Institute, which reversed course after initially endorsing these tools. Even though there are many grassroots organizers and nonprofit leaders who share my opposition, I am an outlier within the legal academy, where scholars on both sides of the aisle are frequently concerned with how we can alleviate the harms of the tools. So my goal today, in contrast, will be to illuminate how predictive technologies reinstate the status quo and to identify legal alternatives that stakeholders can and should pursue in this moment. So very much looking forward to the rich conversation with the panelists as well as your all's questions.
Thank you, Professor Hill. I can already tell that you're going to be part of the fireworks that might occur during the course of this discussion. I look forward to it. Thank you. Chief Anthony Holloway, I call on you for the same purpose of, outlining what you believe some of the issues are that we should reach during the course of this discussion.
Thank you, Judge Dixon. Good morning, good afternoon, and wherever you are. Thank you for letting me be a part of this panel. By no means I am an expert in this field. I only can tell you what my life and work experience is in these fields. Hopefully, by the end of the discussion, talking to you and the panel, we can talk about how law enforcement can use these tools to help bring about transparency, accountability, and show people some of the biases that some of these tools do have and how law enforcement can use these tools to continue to keep communities safe. What I mean by community is where these law enforcement officers are working, because these tools have to be accountable and transparent to the communities that they serve, and they try to maintain safety in their community. I look forward to talking or working with the other panelists here to show you how these tools can be used the right way. And if government does step in, what guidelines we need to put in place so we can build trust, not only in the law enforcement community, but the community as a whole. So thank you very much for having me here.
Thank you very much, Chief Holloway. Ms. Devji Marota, I call on you for the same purpose of discussing some of the issues that you look forward to addressing during this conversation.
Perfect. Thank you so much. And thanks everyone for your introductions. I'm excited for today's conversation. My name is Devji, and I'm one of the founders of an organization called Justice Text. We are a public interest startup that is building technology to promote greater accountability and transparency within our criminal justice system. Our AI software is designed explicitly to help public defenders analyze hours and hours of body-worn camera footage, interrogations, jail calls, and other types of audio and video discovery. What we do is automatically transcribe the footage, summarize it, generate a timeline of key events. And so as an attorney, you can jump to the exact moment your client was Mirandized, administered a field sobriety test, or placed under arrest. I started building Justice Text while I was still an undergraduate computer science student out at the University of Chicago. While I was still in school, I reflected on the fact that so many of the applications of technology that were deployed within our justice system were designed to make it easier to arrest and incarcerate. And there was a concerning and growing technology gap between prosecution and defense. And this, of course, has serious implications for the communities who have been historically harmed by mass incarceration. And so as someone who has scaled a solution from being just an idea, just a school project, someone who comes from outside of the legal system and has been able to work in such close partnership with dozens and dozens of public defender agencies, I'm excited to talk about how AI technology can help address the access to justice gap, especially within a justice system that's so overburdened with overwhelming caseloads. And I'm also excited to discuss the ways in which governments and legal agencies should think about collaborating with technology vendors to mitigate risks, but also to get tailored solutions for their use cases.
Thank you very much, Ms. Marota. And I remind our audience that as we go along this process, please submit your questions through the Q&A. And with respect to our panelists, I will urge them on every occasion to add to the previous response by another panelist or disagree if that is your position. There are risks and benefits of artificial intelligence. I am going to start off on the risk side, but we will be addressing benefits during the course of this discussion. And the first question will go to Ms. Garvey, and that is, what types of bias should we be aware of, judicial officers, law enforcement officers, and others, when AI is used in case management systems, evidence analysis, court operations, prosecution, defense, etc.?
In my view, there are at least two sort of broad buckets of where bias shows up in automated systems, in AI systems. The first is the bias that's introduced by the AI system itself. And there are numerous sources within the life cycle or creation cycle of a given AI system where these biases can show up and must be looked for. Data collection. Is the data being used to train a system representative of what it actually should be representative of, or does it represent historical biases within arrest data, for example? The data processing, how are we tagging the data as it's being input? Is that accurate, or again, does that reflect historical biases? The model development itself and the validation, what are we comparing success against? The deployment, what is the context in which we're using it? And how do the lessons learned in that context feed back into the system, particularly if it's a system that continues learning? So these are the biases, the risk of bias that's introduced by the system itself. And something I will probably be coming back to again and again is, because of these biases and the risk of bias, the importance of independent, transparent testing of the development of these systems at every stage in the development by independent parties who do not have an interest in the end functioning and deployment of a given system, and the necessity for pure transparency of these systems and the inputs of these systems to the adversarial process in order to continue guaranteeing due process and the rights of the accused. There has to be transparency into the nature of these AI systems, how they're developed, et cetera, to the defense. The other major bucket of bias, and we really can't ignore it, is automation bias. This idea, this tendency of folks dealing with machines to trust those machines, to place undue faith at times in the decision just because they're made by a machine. I come back to, I believe I heard it first from Dr. Cedric Alexander, former president of the National Organization of Black Law Enforcement Executives, who called it the aura of mathematical certainty. And I really like that framing, this idea that just because it's math, we have the tendency to say, therefore it's unbiased, therefore it's accurate, therefore I can trust it. And that's not necessarily the case. The same as we would reach in the criminal legal system, we need to treat new AI systems the same way we treat new scientific discoveries. We need to look at foundational validity. We need to look at reliability metrics, again, testing in operational conditions, et cetera. So I think I like thinking of it in terms of those two buckets. There are probably others. I look forward to hearing what I missed in that framing from other panelists as well. But that's where I start when looking at an inquiry into what risk of bias is a given system introducing into the criminal legal context or a given case.
Ms. Garvey, you made me think of something as you were describing those biases, and that is the one where after we have addressed algorithmic bias, data bias, implicit bias, and all of the other types of biases, after the AI gives its result and we have our human review, all of a sudden the human goes, oh, this is not right. I know that neighborhood, and it reintroduces the bias that we tried to eliminate. So it's going to be a never ending cycle. Professor Hill, you started off talking about bias. You want to respond to any of these?
Yeah, definitely appreciate Counselor Garvey's points, as well as your points, Judge Dixon, particularly in the realm of, as I mentioned, pretrial risk assessment instruments. So I'll take this in reverse. So first I'll say, to your point, Judge Dixon, that you have actors within the criminal legal system potentially overriding the scores. This has been demonstrated as a phenomenon in states where these tools have either been deployed locally or on a statewide level. Highly recommend to the audience checking out Megan Stevenson's Assessing Risk Assessment in Action, where she did a close study. She's an economist by training. She did a close study of pretrial risk assessment in Kentucky. In particular, the developers of the tools, the manner in which they designed them, it should have led to dramatic decreases in the pretrial detention population. And her study of the tools after their deployment found that judges were overwhelmingly overriding the scores, and they were overriding them in racially biased fashions in particular. So I think that's a really great example, concrete example of pretrial risk assessment in action. To this question of bias, when I first began working with the tools, I had a steep learning curve coming out of practice. And what I soon discovered was there are various and conflicting definitions of bias based on who is asked what qualifies as bias. So in particular, in the realm of algorithmic instruments, and I'm talking about their construction as opposed to when they're actually being deployed in the courtroom. So when they're being constructed by developers themselves, there are myriad metrics of equality that they can utilize. And the overwhelming metric that many developers are using is called predictive parity. So predictive parity means if I am classified as low risk regardless of what my race is, the label of low risk carries a particular connotation. There is a particular probability that I will be potentially rearrested. That's predictive parity across racial groups. So many of the technologists who were constructing the tools emphasize that, hey, the tools are not racially unfair, generating racial inequality, because they're accomplishing predictive parity. Regardless of whether you are white or Black, if you are labeled as medium risk or high risk, the meaning that's assigned to that risk label is going to be the same regardless of your racial identity. However, there is a different metric of equality, and this is something that ProPublica was able to uncover several years ago in Broward County in Florida, which is we can also measure equality by the rates of false positives versus false negatives. So one particular side of critique for the instruments is the rates of false negatives for Black defendants are exceptionally high, meaning Black defendants are having a higher probability of being labeled high risk, even though they have a very, very low probability of actually being rearrested, or getting this label of high risk and actually not being rearrested after receiving that label. And unfortunately, many of the tool developers are not prioritizing equalizing rates of false positives and false negatives, because they are of the position that this will affect accuracy at the end of the day. And so instead, we have overwhelming use of predictive parity. So I think it's quite important for those who are newly engaging with this literature to understand that based on who is asked about fairness and equality, you're likely to get quite different answers, because there are certain lenses that folks are deploying.
Professor Hill, I'll have to come back to you a little later in this discussion, but we've now established that we should be very careful about trusting the first human analysis. We should be very careful about trusting the AI decision, and we should be very careful about the human review overriding the AI decision. It's our audience is going to be left struggling what to do. Now, before I get accused of just focusing on the negative, let me turn to Ms. Marotta to tell us about some of the positive uses of AI that she's found, especially, and I hope this is part of her answer, with respect to her organization's assisting defense attorneys reviewing body camera footage, reviewing interrogation videos and phone calls. Ms. Marotta?
Yeah, no, and just building upon the conversation that we were just having, I think one of the things that I'll emphasize is that AI is almost too broad of a term. I think Ms. Garvey did a really good job of kind of piecing out extractive forms of AI, predictive forms of AI, and generative forms of AI. And so I'm going to try to touch on all of them, but with the understanding that different applications of this predictive technology is going to have different risk levels associated with it. And I also really agree with Professor Hill in saying that many of the predictive applications in sentencing decisions, parole decisions, unfortunately have extreme racial bias and should be taken with serious consideration. Okay, getting to the positive sides. I think in doing this work and building this organization, one of the things that I've realized is that a lot of injustices within our criminal legal system are perpetuated because of a lack of innovation. And, just talking about different types of examples in correctional facilities, when people don't have up-to-date, easy to navigate databases for tracking information about detainees, parole decisions can be made in very delayed fashions. Medical services are not provided in timely fashion as well. Within court jurisdictions, there's been a lot of research done around how mailing court dates can lead to very high failure to appear rates. And there's been a lot of innovation done around transforming that communication to a text-based system. In the work that I'm doing, working with public defenders, it's been truly, truly inspiring to see how hard they work in light of the overwhelming caseloads and lack of resources. And specifically with the work that we're doing with Justice Techs, we realized that body camera footage, interrogation videos, jail calls could be such a powerful tool for accountability, But, we actually didn't create the infrastructure to help public defenders get through a lot of this data. And so a lot of it was sitting around, a lot of it was contributing to a lot of these overwhelming caseloads. And so what we got started building was an application of natural language processing that synthesizes all of this information and provides it in a much easier to digest fashion. And so I think the work that we've done at Justice Text just goes to show that there's so much low-hanging fruit in inefficient, slow processes that take a lot of time and ultimately have a very serious negative implication on justice impacted communities. And, along with thinking about how to mitigate risk and bias, I think it's very, very critical for leaders within correctional facilities, police departments, public defender agencies, prosecutor agencies to also be thinking about what are those bottlenecks within their offices, within their procedures that technology can work to help and address.
Okay, thank you. Thank you, Ms. Madota. And before we get to any questions that may have come from the audience, let me turn to Chief Holloway. At this point, you probably feel like there's a target on your side of the screen, Chief Holloway. It's not. Would you sort of describe, just give us a list of the types of artificial intelligence that are used by police departments? That is, what do you use them for? What do they do? And if you want to talk about the risks and benefits of each, you can do that as you describe them or as we go further in this discussion.
Well, again, thank you for inviting me here today. And I think the three experts here have done a great job, and I'll agree with them on certain things and I'll disagree with them on other things. And I'm looking forward to that interaction there. I think Mr. Gavin started off the right way of talking about the biases that are in AI. And I'm going to talk to reality, not my expert opinion on this. I'm not an expert. So I'm going to go through the level that I see. And you're absolutely correct. Is the data that's collected that is put into the AI system that the officers tend to follow. So the first one is predictive policing. Everybody hears that. That's a great word out there. But when predictive policing started, it was really to look at the crime trend. Where are the crimes happening? Where are the burglaries? Where are the robberies? But then we turned around with AI and we started using AIs. Where are we making the arrests? And if you do that, I can create, and I said earlier we had our discussion, I can create a hotspot anywhere in my city because all I have to do is move a team to a certain area and I can say this area is now a hotspot for drug. This area is a hotspot for traffic because the more enforcement that I put into that area, the more I can change the way AI is thinking or way AIs can perceive where crime is occurring. Whereas I'm not looking at the raw data where people are reporting crime. So when you're using predictive policing, it should be based upon, and it is great technology because it tells me where I can put those officers. If I know every night on a Wednesday night, this is where burglaries are going to happen, then I have to look at that layer. Like I said, transparency, and then verifying where that data is. So predictive policing can help out. That's one tool that tells me this is where all the burglaries are happening. But then I have to also look at that layer. If that's the only place that I'm making the arrest, then I'm going to also assume that's the hottest area, which it could not be. So you have to verify that one. The next one is surveillance and facial recognition. It's good as a force multiplier. We love using it. But again, we have to verify what AI is telling us. We can't just trust it to say, hey, Dr. Hill, the person we're looking for, and that's why we're going to get an arrest for Dr. Hill. Really, you're going to have to go back and say, hey, let me get more information. Put in a human factor. We just can't depend on it. But again, it's a false force multiplier. The other one is natural language processing. Because we receive so much data, we're trying to get search warrants. We use AI to help us out with all those things that are out there. Look at review social media. Who's talking to who? What's being said? What are the algorithm in that? What are they planning? And again, it's a good tool, but it also has to be a tool that you have to verify information on because it can gather up more tool and save resources and manpower. Body cam footage, I heard Ms. Mendoza talking about that. I think that's a great tool that's out there. We're still learning about body cam footage. But again, as I said on the American Bar Association, when we first started talking about body camera, the body camera is forward facing. So it's only looking at the suspect. It's not looking what the officer's doing because again, what's the interaction? And now I know they're trying to look at what's the officer's tone of his voice when he or she talking to someone. Did they step into that conversation already ready to confront that person in a different manner because they're working in a different community? So again, it's a good tool to be used, but how are we using that tool? How are we making sure that it is accountable to the community and to the officers, transparent to the community officers, and then what's the bias basis that are in there? Alex, I can keep going on. I'll go with the last one is incident response dispatching. And again, what's being fed in there and who they're feeding the hot spots to that information. It does help move law enforcement, put us in the right place. I always say it gives us the best guesstimate. It tells us the best place to possibly go fishing, so to speak. But again, you don't want to keep fishing in the same fishing hole because then you create a hotter spot for that area. So I'll end it right there. But like I said, there are a lot of good things that AI can be used. But I'll go back to part of Ms. Gavin's conversation statement is that you can use it, but you better have some human element that you got to verify what you're seeing and not just believe it and just trust it and act upon just what the computers are telling you.
Okay, thank you, Chief Holloway. One use that I have by law enforcement that I have found amazing, it used to be done just by legwork with the detectives, and that is the forensic type evaluation of DNA evidence, where they have been able to find serial killers based on DNA that was left on the scene by going to public databases. And if they find someone, as I understand it, and some of you may know a lot better, if they find someone who is as close as a third cousin, that is, they have the same great-great-grandparents, they're able to conduct their investigation, and by a process of further investigation and elimination, they can actually get to the individual who left the DNA at the crime scene. That, in my thinking, that's been a game changer, but there may be risks associated with it also. Let me turn to Ms. Garvey for just a second, because she mentioned initially facial recognition. What are some of the benefits and issues that have risen concerning the accuracy of facial recognition technology across demographics? That is risk and benefits.
Sure. As Judge Holloway mentioned, I think the perceived benefit of facial recognition is this force multiplier. Rather than looking through mug books, if you can have an algorithm do it, find people who you otherwise wouldn't have been able to find, or do it much, much quicker. There's an incredible appeal to the idea of being able to take a photo or video, a photo of an unknown person, or maybe a video of a crowd of people, feed that into an algorithm and determine who is in that photograph, who is in that video. You can even extrapolate associations from a crowd of people, maybe even movement across time. If you have enough cameras and are feeding enough data into a face recognition system, you could also generate a pattern of someone's behavior as they move throughout a well CCTV carpeted city, if you will. The risks are a couple-fold. Taking that last example, that last very real potential for facial recognition, that's a privacy question. That was a very similar question to what was before the Supreme Court in the Carpenter case. The idea of the right to privacy to one's movements and associations across time, even if an automated system can actually collect and extrapolate that information about somebody. There's a real tension between saying our face, we present our face in public, of course our neighbor might recognize us. A law enforcement officer might recognize us from prior interactions and whatnot. But if we're at a public protest, for example, law enforcement can't go through a protest and somehow secretly identify everybody by, I don't know, pickpocketing them and looking at their ID. Facial recognition can make that possible. Is that a line we want to cross, and where does the law come in and say, no, actually, the First Amendment protects the right to anonymous speech, anonymous association, and just because we've developed a technology that can breach that doesn't mean we as a society want to go there. As a practical matter, in the US, the vast majority of use cases for facial recognition are in the investigative lead. I think Chief Holloway also mentioned this, the idea that it's generating leads that will then be verified. The challenge here is that, yes, in theory, having facial recognition be an investigative lead only that must be corroborated is in theory a check against the risk of misidentification, any risk of reliability, questions or error that the algorithm might be introducing into the equation. What this has meant in practice and what we see over the last 20 odd years, however, is that this investigative lead only label that's been put on facial recognition has meant that there's almost been a complete lack of transparency to the defense around the use of a fundamentally unproven tool. Facial recognition, as used in the criminal investigative context, is a biometric forensic investigative technique that has never been established as forensically reliable. There are lots of tests saying the algorithms are X reliable, but as it's used in the criminal investigative context with a vast array of different quality images being fed into the systems, sometimes sketches or forensic busts being put into the system, photo editing at play, and then an analyst who's looking through a candidate list that the facial recognition system produces and determining whether there's a match. That person's not certified because there's no certification for facial recognition analysts in the US. They may not even be trained. That system as a whole has not been determined to be reliable as it's used in a given investigation. And yet that whole process, that process that we don't know its reliability is very often not disclosed to the defense. So what we have as a product is we have a tool that has this perception of being extremely useful, extremely valuable, expediting search processes, but may be resulting in misidentifications. And even when it's not resulting in misidentifications, may have errors under the hood that the defense has not been able to challenge in a vast majority of cases.
I am aware that with respect to facial recognition technologies, there are several jurisdictions that have banned law enforcement's use of it. Some of the more recent bans seem to be more related to privacy rather than accuracy. And it causes me to just reach out at this point, Ms. Mathewson, because you told me that your folks review body camera footage and videos. Do you ever get involved with the facial recognition aspect of this?
I think, yeah, it's an interesting question because we made a pretty explicit decision in the early days of developing the technology to just focus on analyzing the audio stream. So analyzing what was actually spoken, said, generating the transcript, pulling out key moments based off of that, and kind of avoiding facial analysis altogether, just because of a lot of the controversy associated with it, a lot of the research that was still coming out. However, within the last 6 months or so, we've actually had a lot of public defenders that we work with reach out to us and tell us that it would be helpful if the technology that we've built could help them do basic object detection. You know, tell them at minute 5 there were 3 cars on the scene, or at minute 3, you know, there's something that potentially was a weapon. A lot of technology that police departments already use. We've started getting requests for that. I think there's been also requests for facial detection, which is different than facial recognition. Facial detection basically just tells you, you know, this is the image that was detected on the scene. There seemed to be 3 men, 2 women within this 50-minute body cam interaction. A big reason for this is that oftentimes as a public defender, you're getting a largely unlabeled, unorganized data dump of footage. If there were 5 different officers on the scene, it can take a lot of time and effort to actually build out that timeline and synthesize how all of these different moving parts, how all of this footage fits together. And so a lot of them tell us, you know, it'd be really nice for us to be able to say, Officer XYZ, which of these files did his face appear in? But that's separate from facial recognition, where we're not telling the end user who this individual is in fact. So I think it's been interesting because in developing justice texts, we've been directly responsive to the feedback that we receive from public defenders, and that's been the most meaningful part of the tool. And so we are starting to experiment with basic object and face detection, but I do think facial recognition in and of itself is something that we're going to avoid altogether.
I want to remind our panel members that any point you should feel free to jump in to either extend the remarks or to disagree with some aspect. Chief Holloway, you just went on mute. I wasn't sure if you were trying to get my attention or not. You just went on unmute.
Yes, sir. Your Honor, I want to jump in there, and I want to agree and disagree. Facial recognition is good to a point. I would say any at large. Here we have large venues, and if we're trying to look for a suspect that we think that he or she is trying to cause massive damage to an area, then we should be able to use that technology to do a quick scan. It's again, a force multiplier. If we're having a baseball game and there's 80,000 people there, but we know of a subject that's threatened to do something to that venue, then we should have that tool available to us so we can go through those people very quickly. But day-to-day use, no. I think, again, it's back to that human part of it. I think we should have a right to stop that person and say, hey, Mr. So-and-so, you're that person we've been looking for. There's a possible threat. But average traffic stop day to day, no, it shouldn't be used for that you're looking for a person. I think is, what are you willing to give up with your privacy concern? You have to weigh that. And that's where you get the guidelines from the court. If you're talking about a massive group meeting and you're trying to locate a suspect that's a harm to the community, then facial recognition should be used to try to locate that person as quickly as possible. But to try to identify a subject, as Ms. Gavin said, at a protest that has nothing to do, but they're just under their working on a First Amendment, freedom of speech, then no. But again, like I said, and that's where that line crosses. Where do we draw that line? Because we do need that technology because it could save a life, but at the same time, you have to make sure that law enforcement does not misuse that technology. And that's what we ask the courts, and that's what we're asking this group. How do we make sure we keep everybody safe, but also how do we make sure we protect people's privacy at the same time?
Now, Professor Hill, you don't seem to have any lack of opinions on these various subjects. Where do you come out on the issue of facial recognition technology?
Yeah, I'm not as familiar with facial recognition. I'm more familiar with things like ShotSpotter, which are supporting officers, and the sell from technocrats is this is going to aid officers in identifying where guns are being deployed and utilized. And so I didn't comment because my expertise is not in facial recognition, but I did want to share following Counselor Garvey's remarks about some of these constitutional protections that we are compromising. And, hopefully I can speak to also some of the questions I'm seeing in the Q&A about how courts are responding to these technologies in this moment, particularly when it comes to constitutional protections. And they're really struggling. And that's evident if you're looking at either state or federal cases. So some of the constitutional protections that I'm quite concerned about, Counselor Garvey already referenced things like our First Amendment rights to speech, but I'm also concerned about the ability of defendants to confront witnesses. So you have courts across the country that are automatically admitting data that has been generated either by Google Maps, GPS, or surveillance or otherwise, and they're not requiring the developers or the individual who utilized that tool to actually appear in the criminal case to be confronted. So I'm concerned about Sixth Amendment rights being compromised. And to give a more concrete example in the context of pretrial risk assessment, again, that being more of my wheelhouse, in Wisconsin, maybe 5 or 6 years ago, in the case of State v. Loomis, that's Loomis, you had the Supreme Court of Wisconsin confronting a claim made by a criminal defendant who had been subjected to, I believe, a sentencing risk assessment, and his claims were grounded in the Due Process Clause and the Equal Protection Clause, namely stating, because I don't know how this score was generated, this is depriving me of due process of law, and then relatedly, because men are more likely, based on the data that's being utilized, men are more likely to be labeled high risk than women are. He also made an equal protection claim grounded in gender discrimination. And notably, the company that owned this, I cannot remember if this was Compass or Arnold, but they offered to file an amicus brief to the court to explain how their tool generates its scores, and the court declined the brief. And one of the dissenting justices emphasized this in her opinion that, we are endorsing the use of these tools. The court ended up recommending that disclaimers be published alongside the score. So letting judges know, I think even to Chief Holloway's point that, you should not exclusively rely on the score, you should draw on other metrics in order to reach your conclusion. So the court ends up reaching this decision, this holding that this disclaimer is sufficient, even though it had declined, information on how that tool had been constructed from the developer themselves. So I think that this is representative of we've made this rapid transition to these technologies that our legal system is really struggling to catch up with. And appreciate Counselor Garvey's reference to the case of Carpenter, which is exceptional to Supreme Court case, but you do see the court struggling with its analysis and where it's going to ground potential protections, including possibly in Fourth Amendment protections. But the courts are quite hesitant to pursue that pathway because they want to leave a great deal of discretion to police officers. So I think that these are representative of some of the presumptions that folks might have, which is that our legal system is going to shield citizens from, these overreaches of the state. But unfortunately, when we look at the reality of many of these cases, unfortunately, that's not how things are actually turning out.
Just a follow-up, Professor Hill, do you find now that there has been more litigation over these risk assessment tools, that the trend now, at least things are trending towards, there must be some more transparency in how these AI platforms reach the decisions that they reach?
So that's a good deal of what legal scholars who I referenced at the beginning of the session, that there are scholars who are attempting to facilitate greater input and transparency, and that includes oversight. So how can we empower communities to actually be able to influence the tools? And I would say that, litigation, I've not confronted a tremendous amount of litigation, and that's partly because it's partly that the tools, the individuals who are adopting the tools are elected officials, and I don't know if it's an appetite. I could not probably explain why it's not being litigated more. What I would say is that there are plenty of legal scholars who are attempting to identify how can we actually have community control. I'll put one into the chat. Her name is Ngozi Okitaba. She's at Boston University Law School. She's been doing a tremendous amount about community control of these tools and fostering some more community input beyond maybe traditional litigation strategies. But I'll put her name into the chat.
Let me take a moment and just become vulnerable for a second and share with the audience one of my concerns about artificial intelligence. And it's not just mine. I think it rests with quite a few judges. And that is deep fakes in the courtroom. There was a case that actually made news this year, and I think it was national news. It occurred in nearby Maryland, where an audio recording surfaced with respect to a school principal making derogatory comments about African Americans and Jewish individuals in the school. And once that recording became public, it went viral. It went viral to the extent that there were threats against the school principal. The police had to increase security around the principal's home. There were some folks who said that knowing what they knew about the principal, it didn't surprise them that he made those comments. There were others who were strict defenders of the principal, saying that they couldn't believe that he actually said anything like that. This principal was lucky. The police department shared the audio with two different forensic analysts, and both of them came to the same conclusion that parts of the audio was either manipulated or created by using artificial intelligence. Police were also able, using the IP address, to track the original transmission of the audio to an email address where there was a relative of the eventual charged defendant in the case. And it turns out that the defendant who was charged was on the verge of termination by the principal, had done a fair amount of research that they found on his computers with respect to audio manipulation, and they cleared the principal. Now, he is very lucky that the police were able to consult with experts in that field to analyze the audio. But with the availability of artificial intelligence to manipulate audio and video, not everyone is going to have that benefit of an expert. And so now I'm looking at this occurring in a courtroom where the proponent of the evidence says that this video or this audio proves what I've been saying about the agreement or the contract that we reached, and the opponent saying this thing is a fake. You have the judge who now, under traditional rules of evidence, if you have a proponent who says this is what it purports to be, it's admitted and you let the jury decide. Think of how that is without expert witnesses to assist, letting the jury decide. Now, the jury is likely to get it right sometimes, they're likely to get it wrong sometimes. What has occurred to address the issue, but it has not reached a conclusion, is as follows. There have been proposals with the Advisory Committee on Federal Evidence, and they fall into two camps. One is the first time that an individual offers some evidence that the opponent declares is a fake or was manipulated by artificial intelligence, then one school suggests that when that objection is raised, then a hearing has to be held, and the proponent, the person who's offering the video, needs to come forward with some sort of corroboration that the video is true and accurate, other than just their testimony with respect to saying it's true and accurate. Also, the proponent is given the opportunity to produce evidence if it can be established that the evidence is fake. The quickest example I can give about that is that the opponent is able to offer evidence that he or she was in a different location at the time that supposedly occurred, and therefore he could not have possibly done what it is that's alleged. Another proposal with the federal rules of evidence, and it's my guess that this is the least likely to succeed, but it's radical. And that is, the judge will make a decision on the admissibility of the evidence. And if the evidence is admitted, the judge will tell the jury they have to accept it as authentic, and they will instruct the defense counsel that they may not argue that it is in any way fake or manipulated. And which I think is a pretty difficult proposal to make. I'm not sure that most judges want the responsibility of making that decision at that point, even though that's our lives. Any of you have any thoughts about my dilemma? That is how to deal with these deepfakes, because it's something that I know is coming. I've written an article on it that's just being published. It's called the Deepfakes Defense and Evidentiary Conundrum, because that's what it is, a conundrum. Any thoughts, anyone? Okay, I've gotten pure silence. Okay, that's terrific.
I'm happy to weigh in a little bit on less on deepfakes, but more on, I think it's a symptom of a more broad problem in the criminal legal system that we're seeing. And that is that these cases have gotten extremely complicated, and lawyers and judges are not experts on artificial intelligence and probabilistic genotyping and deepfakes and audio and video editing software. And the question really becomes, is the criminal legal system equipped, and how do we get it equipped to deal with these extremely complicated questions? Now, you raised one of those questions, and that is, or one of the possible solutions, and that's an expert witness. My fear in a lot of this, and I think what we see a lot, is the more complicated a case gets, the more likely we are to get a plea deal. 98% or thereabouts of criminal convictions come from plea deals as opposed to actual litigating these questions. And I think the more complicated a case is, the more pressure there is on a defendant to take a plea deal, which means, as a practical matter, a lot of these issues, we're waiting for those 2% of cases to get through that plea negotiating, that plea bargaining system. We're only relying on these 2% of cases to actually hit the meat of these questions in the criminal legal system, or we're only dealing with them at the pretrial level with a probable cause threshold, which means that the adversarial system is not actually being brought to bear on these extremely complicated questions. And it's a common refrain that we hear from defense attorneys, is that they lack the training and time and resources to deal with this, but on them to be raising the challenges. And they're also then left responsible for training the court on these issues. What is a geofence? What is a deep fake? I have a great quote from a defense attorney from an interview I did the other day that just says that is the other aspect that makes this so troubling is a lack of understanding on how the technology works. We go to a discovery hearing on this, and judges need an entire set of briefs. The technology is being developed and being used so quickly, there's a lack of understanding from users and the stakeholders. If we're lucky enough to be educated, the judges are like, hold on, you have to teach us about this. And then the defense attorney went on to say, we need another word for the blind leading the blind here. And it's extremely troubling to think of our criminal legal system, which has rules in place to guarantee fairness and accountability and transparency and the reliability of the evidence being used in cases. And that an active practitioner in that space would say, and it's the blind leading the blind. So not a solution necessarily, but just adding maybe to your sort of general anxiety or fear around where we're going and where we're going extremely quickly in the criminal legal system without this robust backbone of education and training and competence and reliability testing and whatnot.
Yeah, I thought it was a great question, Judge Dixon. I was looking up the article you referenced just now because I said, oh, I want to definitely check out this deepfakes piece. So please, I hope you'll send it to us separately. I couldn't have said it any better than Counselor Garvey, which is my inclination is, yes, litigate these issues and to hold a distinct evidentiary hearing. The realm that we've seen that be slightly effective was in the context of bail. So at the federal level, if you intend to detain someone indefinitely pre-trial, you have to hold a pre-trial detention hearing. And that was one of the strategies that we utilized in New York was to say, if you in fact do want to pursue this strategy of indefinite detention, which was otherwise not available, well, we should adopt the federal posture. And unsurprisingly, New York state legislators did not want to go for that. They did not want to go for additional hearings, additional procedural protections. So I think that your question goes to my concern, which is that we have fundamental problems with the criminal legal system, including, as Counselor Garvey has pointed out, 97% of criminal cases are resolved by plea deal at both the state and the federal level. So if we don't have litigants actually having robust guarantees met in terms of being able to actually bring cases to trial, I'm quite hesitant to endorse an approach that would have evidentiary hearings for such a small proportion of criminal cases. If we could actually guarantee more robustly the right to jury trials and the right to trials generally, I might be more comfortable endorsing, a strategy of let's at least have these litigated by way of evidentiary hearings.
Okay, let me do a quick round of benefits of AI. And while you're thinking about the benefit that you want to mention, I don't want anyone in the audience to think that we're only talking about the risk of AI. And there's one benefit that comes to mind with me, concerns electronic document analysis. One name by which it goes is predictive coding. And that is with the availability of terabytes sometimes of documents, we've reached a point where it's become almost humanly impossible within a reasonable time to evaluate all of those documents, looking for documents that are relevant to the discovery request. And that this occurs in both criminal and civil cases. And with the advances I'll just refer to it as predictive coding, e-discovery, but predictive coding, it has reached a point through a process of machine learning and with reiteration, once you develop some sample documents and turning alerts the machine, this is relevant, this is not relevant, and you go through that iteration several times, we now have artificial intelligence applications that can go through terabytes of information in very short periods of time. And many tests have demonstrated, and this is a follow-up, with respect to known data sets, when we compare what the artificial intelligence predictive coding is able to do versus a set of human beings reviewing the documents, I think it's now reached the point where it's undisputed that the electronic analysis of the documents for relevancy with respect to the criminal case or the civil case, the application's determination of relevant documents is now the gold standard, as opposed to individuals sitting down reviewing one document after another. Let's see. I'll start with Chief Holloway. Is there some particular artificial intelligence use that you've found to be really of a benefit that doesn't seem to have the risk that we've been describing?
Your Honor, I think the biggest thing out there now is really changing law enforcement is NIBIN. It's a forensic thing. Is the National Integrated Ballistic Information Network. And what that is anytime someone fires a gun and a shell casing is left behind, we can look at that shell casing and then we can match that shell casing to any shell casing in the United States. It's put into a database. So when we finally do arrest a subject and we take a gun from that person and we run it through the machine, then I can tell you how many times that gun has been used in a shooting throughout the city or throughout the nation. So that's causing us to close a lot of cases. So that way I see AI being usually truly as that, is looking at the evidence, is matching it to that gun. And if we can put that person at those scenes, then we can lock those cases in. So to me, NIBIN is the strongest AI technology we have right now.
Okay, and once again, the question relates to some type of artificial intelligence use that has shown more benefits than it has risk. Ms. Mathewson?
I think The way I'll respond to this is talking about the fact that this technology is evolving at an incredibly rapid pace. When we started building justice techs 4 or 5 years ago, the state of speech recognition technology, which is at the core of a lot of that transcription work, was not very good. It wasn't very good at identifying different speakers. It wasn't really good at filtering out background noise, police sirens. And, there were clear biases within its performance on under-resourced languages, underrepresented dialects, African American vernacular, foreign languages, etc. The landscape of natural language processing has transformed so completely within a very short period of time that the capabilities that we're able to build out, the risks that we're able to now mitigate, are also completely different. And so I think one thing that I'll say is that this technology isn't going to be perfect. But if you work in close collaboration with, vendors, technology partners, whoever it may be, you can realize that the capabilities are only going to continue to improve over time. And I do think it's actually incumbent upon a lot of practitioners in the space to keep an eye out on how the technology is evolving so that they can make those decisions and deploy that technology safely. I think just going back to the work that we're doing specifically, just describing that specific use case and building upon what you said, Judge Dixon, along with paper discovery, the video discovery is another element of, the workload challenge that different practitioners are dealing with. And for this technology to then go through all that footage, summarize it, allow you to query high-level questions. Are there any exculpatory statements in this file? Are there any implicit promises made in this interrogation video? Are there any weapons or drugs mentioned? The technology can do all of those things very reliably in very, very accurate and reproducible fashion now. So, the ability to synthesize text, to generate summaries, to create timelines has a different risk factor than, something that facial recognition may have or like a predictive tool may have. So I'll just kind of leave it there that there's so many exciting applications of these tools. And I would just encourage everyone to kind of explore them and make sure that they're leveraging them in their work while also being concerned about a lot of the safety considerations that we had.
Professor Hill, do you wish to step forward in terms of some artificial intelligence use that has shown more benefits than risk?
Unfortunately, I will not be able to speak to all of the fantastic ways I've seen these deployed, at least in the pre-trial context. And again, I've appreciated the insights offered, by Chief Holloway and others about what this can look like on the ground. Part of my goal in this research and in speaking to audiences is to really illuminate how there are straightforward solutions available that do not require us to rely on the adoption of these tools. So particularly in the realm of bail, I like to emphasize how many practices that we have been normalized are actually relatively recent developments, including things like predicting, quote unquote, predicting the dangerousness of pretrial litigants. That was not a practice until probably the 80s or 90s. And you had Justice Thurgood Marshall, who many on this virtual event may recognize. He was writing impassioned dissents in these cases when the Supreme Court was first authorizing in cases like Shaw v. Martin and Salerno, when they were first endorsing allowing judges in the pretrial context when when defendants have only been charged with crimes, allowing judges to make for the first time in our country's history assessments and predictions of dangerousness. Thurgood Marshall was writing impassioned dissents, emphasizing that both clinicians, empiricists, and various others had disclosed that you cannot reliably predict the dangerousness of an individual. And much of what we've been seeing in the realm of pretrial risk assessment is only affirming these very early insights from the 80s and 90s. So in my mind, I'd like to emphasize the alternatives, the legal alternatives that are available. I've made several references to New York State, which chose to go down a pathway. It's now the only state in the country that only permits bail to be set to ensure future court appearance. They opted to only permit bail for certain criminal offenses, and they reduced the number of individuals who would even be subject to pretrial detention. I like to reference the Bail Reform Act of 1966, which was the product of the Civil Rights Movement. That federal act, which was only in effect for about 10 to 15 years before you had the next Bail Reform Act in the 80s, but this Bail Reform Act of 1966 only allowed judges to make these assessments of dangerousness when an individual had either been charged with a violent felony offense or when they had already been convicted of a crime and sentence was pending. So I think that we have really wonderful, workable solutions available to us that don't require us to turn to these technologies, which I think, again, to points that have already been made, we are not sufficiently equipped. I think events like this are important to actually be equipping individuals, but really we should have been holding many of these events before the adoption and use of these tools. And so given their proliferation, you know, I fall on the side of can we identify, can we pursue legal interventions, policy campaigns that are grounded in, you know, ensuring constitutional liberties and protections are available to all individuals, regardless of race, class, gender, or otherwise. So, you know, I've not seen great examples. I think one example that I did think of, there were some early studies done around failures to appear in court and why individuals were not coming to court, because we oftentimes presume out of a large population that all of these individuals were intentionally trying to avoid you know, a criminal case, but many people simply can't afford childcare. They can't afford to get to court. They may forget their court date. They may have competency issues that contribute to why they're unable to make these court dates. I have seen technology utilized in these pretrial contexts to identify why is it that individuals are not coming, identifying that the majority of these individuals are not actually trying to abscond from their cases. Rather, they just need reminders, and then utilizing that data to then change approaches, including things like pretrial reminders, simply making a call to individuals or sending a letter in the mail letting them know of their next court date. Those types of uses of technology I have found quite promising, but I would probably categorize them as exceptional, at least in the pretrial context.
But we still got you to the point of telling us some of the AI technologies that were beneficial. I knew we'd get you there, Professor Hill. Thank you. Ms. Garvey, once again, identifying any particular artificial intelligence technology that you found has more benefit than risk at this time.
I have a difficult time answering this, not because I'm trying to avoid the question, although maybe I am, but I'm not a technologist and I don't test the reliability of these tools. And to me, the more important question is less, does this AI system show promise and what is it trying to solve?
Understood.
And more, is it reliable? Does it do what it says it's going to do in an unbiased way? This is going to sound flippant, but I mean this in all honesty. When we're engaging new tools in the criminal legal system, particularly in the investigative and evidence generation context, if we're going to rely on these tools, they have to be reliable. That feels very basic to me. And yet we have instances with facial recognition, with predictive policing tools and risk assessment tools where we are employing and essentially beta testing extremely unreliable systems, or systems where we don't know how reliable they are in operational contexts, in advance of asking the very basic, is this reliable question, and then testing it, and then setting up adequate foundational validity testing for these systems. does the court system answer some of these questions for us? I think yes, it does provide us with a framework, and I'm cognizant of the fact that there are a lot of questions in the Q&A, and I think this is speaking to some of those questions. We do have 702 and Fry and Daubert, this system of scientific evidence being introduced. How reliable is it? What threshold does it need to hit? In my experience, a vast majority of these systems are being used in an evidence generation stage at the prior to a level where it hits the Fry-Daubert question. Maybe it's being considered an investigative lead only. That doesn't mean it's not relied upon to make arrests. It just means it's classified as this sort of doesn't need to be disclosed to the defense. There's an incredibly close relationship here between these reliability questions and whether we even ever meet them, and transparency and disclosure to the defense. And historically, there has been huge barriers put in place to the defense, to the public at large, but to the defense gaining access to adequate information about these tools to be able to answer that very basic question: are they reliable? And if not, why are we relying on them?
Chief Holloway, quite often the subject of criticism regarding the use of artificial intelligence is law enforcement, the police department, the prosecutors, et cetera. And I imagine that somehow public education has to come into play with respect to what's being done. Is there any type of effort that you're aware of where law enforcement attempts to educate the public in order to address what law enforcement may feel are misconceptions about the use of artificial intelligence?
I think it's done every day, and thank you, Anna, for that question. It's just you have experts on both sides, and I think Ms. Gavin's hit the right way. It's just proving what part is right. Everybody's still doing a lot of beta testing on what this technology can and cannot do. So no one can really give you a definite answer on, hey, this is what it can do for you. This is how it can help you. The major question comes out is, how is law enforcement misusing these tools? Are they going into someone's privacy, or how far, what's that line that they're crossing over to try to make sure they can make a case? So again, you can educate people more, but I still think it's going to take the courts to come up with a ruling on how these tools need to be used. Because law enforcement, we're going to try it. We're going to take it to the right to the edge until someone tells us we can't use these tools, and we just need a definition on it, and make sure we're not violating someone's right, because they are great tools used the right way. And I keep saying tools, I want to make sure I emphasize that they're a great tool, but you still need the human part of it to make sure that the data is okay, and then who's teaching AI what, and what are we looking for? So just by getting people together, and I think we should do that, getting legal people together, law enforcement together, community together, and the question is, what do you want? How much do you want AI to protect you, and what are you willing to give up?
Ms. Garvey, I think this is one of the questions where you indicated an interest, that is how we can go about educating the public and raising awareness about the implications of bias in the AI system.
Definitely. One of the, perhaps something that AI and then automated systems more generally are adding into the criminal legal system is we are increasingly outsourcing important decisions in the criminal legal context, whether that's what evidence to generate, how to interpret that evidence, risk scoring, et cetera, to an algorithm that's been generated by a third party who has proprietary interests in that algorithm, and in keeping how they made their algorithm a secret. And this is one of the huge challenges that that the criminal legal system faces, this balance between proprietary information on the one hand, now that we have a third party involved, and the constitutional right of a defendant to gain access to information that is relevant to mounting a legal challenge. There's the criminal legal system, our criminal justice system has an answer to this, and that is protective orders. the third party asserting a trade secret interest in information that's relevant to a defendant's case actually doesn't belong in the criminal legal system, yet we're seeing these challenges raised a lot. The system's answer to that is we put a protective order around it so that the defense can gain access while still protecting that third party data. There are problems with that, which I don't think we have time to go into that. But I think this is just one of the aspects where AI and automated systems has introduced a layer of opacity into the criminal legal system that we have to really be careful to not let drive due process violations, because in the absence of protection, it does seem like these third-party proprietary trade secret arguments are carrying the day to the detriment of defendants' due process rights.
Your Honor, may I interject this, sir?
Absolutely. Go right ahead, Chief.
So back to what Ms. Gavin's saying, and I see a question like that, and the thing in chat box is, if we're teaching AI that if the only people we're arresting are African-American male between the age of 14 to 16, then AI is going to tell law enforcement that male between the age of 14 and 16 are still in car. So now the officer is going to go out there and try to find Black males or African-American male between the age of 14 and 16 driving cars. So is it not we're teaching AI then to be biased? It's telling the officers what to look for instead of reverse way around. Because they're just looking at how many arrests, and like Professor Hill was saying, if that's all who I arrest, then that's what AI is going to feed back to me. But we're not looking at another race or another age or another gender. We're just putting data in there, and AI is just being taught on what we're giving it.
Folks, I just noticed the time because there was not any lull in this conversation. And I know in terms of our preparation, I indicated that we would do a round robin, allowing you to indicate takeaways for the audience in terms of comments that you wanted to emphasize or re-emphasize. And so even if you want to respond to the last question as a part of that, I invite you to do so. Let me start with Professor Hill.
Really appreciate your insight, Chief Holloway. It is something that, the saying that Sandra Mason in particular has popularized is bias in, bias out. And that's a recurring conclusion from multiple academics. And so I share your concerns about the data that we're utilizing to design the tools. So I'll just end as a true academic and teacher, which is to share with you all some potential writing materials that you may be interested in following up on. I know that we have some materials on the ABA page itself, but for those of you who are interested, you may want to check out a book called Race After Technology. That's by Ruha Benjamin, who I believe is a sociologist. The Racial Contract by Charles Mills, which I think supplies us with helpful context for understanding these tools. And then a really great book by a legal scholar, Devin Carbata, which is called Unreasonable, which gives us some context for some of these court opinions surrounding our Fourth Amendment rights and protection. So I think that all of these are very relevant to today's conversation. And so I recommend for those of you who are interested, checking out some of those materials.
Ms. Mathewson.
Hi, everyone. I think all I'll say is that, within our criminal justice system, our legal system that is so overburdened and unfortunately not delivering the quality of services that we want to for disproportionately low-income communities, communities of color, technology can play a really important role in increasing and speeding up their access to legal services. And so my experience has been working with public defenders who are on the ground every day, tied up with so many different types of bottlenecks, so many types of inefficiencies in their day-to-day work. And so through the lens of making it easier and more efficient to get through video discovery, I've seen the potential of technology to seriously improve outcomes and lead to positive change. And so, yeah, I think that's what I'll end it on. I'm excited to see how this technology continues to evolve and excited to see more practitioners, leaders like Chief Holloway find ways to bring this work in supporting the communities that they serve.
Ms. Garvey.
Thank you, Judge Dixon. I am feeling really guilty about all the questions we didn't get to from the Q&A. I think it's a real sign of that this is an extremely broad and complex topic that we could talk about for hours and still not get to all the very real questions that AI in the criminal legal system is raising. My final thoughts are this is moving really fast, and I just urge caution with introducing new unproven technologies, AI and other, into the criminal legal system without doing our due diligence on this reliability, accuracy, and bias question. There are mechanisms, Fry, Daubert, 702, to frame this question of scientific reliability. And I think we should build on what we have already when looking at artificial intelligence, but not stop there. To be honest, the criminal legal system is not very good at incorporating new scientific discoveries once they're found. A lot of us woke up in January, late January of this year, to headlines saying AI has found that fingerprints can no longer be deemed to be unique or something like that. That was a kind of a misread of a single article that was looking at similarities between fingers of the same person. But that raises a really real question. What if an AI system that we choose to implement into the criminal legal system, we learn tomorrow, 3 years down the road, that it's unreliable? We're kind of stuck because of case precedent, because of the overwhelming reliance on what prior courts have said about the admissibility of evidence. So I think all of that urges caution. And to the defense attorneys in the audience, the Fourth Amendment Center is here for questions of advanced technology and privacy in your cases. So please don't hesitate to reach out.
And Chief Holloway.
I'll make it very short. Again, thank you, everyone. I always learn something. I co-chair the law enforcement section for the ABA, and we're going to be talking more about this. So hopefully everybody will join that conversation so we can learn more and we can bring more guidelines too about the AI. It's great technology. It's here to stay. We just got to learn how to use it in the best way. And I'll end right there.
Dean Mathewson, I will forego any comments that I have in terms of closing comments because we're over time. I turn the program back to you.
Okay. Thank you for joining us for this free webinar. We'd like to express our gratitude to this esteemed group of panelists. You are all doing critical work, and we thank you for taking the time out of your schedule to share your experiences. We want to congratulate Professor Hill, who has just recently received tenure. Congratulations. The section of Civil Rights and Social Justice provides free webinars and resources for legal professionals and advocates nationwide. We hope this helps you in your work. And again, if you can, please consider joining and becoming active in the ABA. You may do so at americanbar.org/CRSJ. The best of luck to you in your work, and stay safe.